What is the impact on an F1 visa? What would be our legal status once our green cards have expired? Be considered abandonment of the green card. I'm a student on an F1 and currently in my grace period, I'm unable to go back to India. Yes, what would you suggest me do?
Let me introduce everyone to Rekha Sharma. I think most of us know who Rekha Sharma is, but still let me go for a formal introduction. She is a passionate advocate for immigration rights with broad experience as an assistant district attorney and practicing attorney. She is a frequent speaker and lecturer on matters of immigration law. Her fearlessness has put Rekha in the local, national, and even international spotlight as she is taken on extremely complex and high-profile cases that others have turned away. She has spoken at a variety of seminars about immigration law locally at the Johnson County Bar Association, Kansas Bar Association, and Kansas and Missouri Public Defenders. In 2018, the Kansas Bar Association honored Rekha with the Courageous Attorney Award. To help community with immigration concerns, Rekha graciously accepted IAKC request to answer some questions we are facing during this difficult time. Let me remind everyone that this session is only information based, and any answers provided during this session should not be taken as legal advice. Rekha Sharma will share her contact and addresses. Feel free to reach out to her for any legal advice if you need in the future. Rekha, I think I was able to make you a co-host. Will you be able to present?
Of course. So what I'm going to do is I'm going to, since you've made me a co-host, I appreciate that. I'm going to spotlight my video like that. First of all, namaste everyone. Good evening. I hope everyone is keeping well, staying at home. I appreciate the opportunity to speak to all of you. As you know that it's very important to me that the community understand, is aware of, stays far away from bad information, things like that. So I really appreciate the opportunity. We have an hour or so, and I will take your questions. There's a number of questions that people had sent in, and I will address them. However, I want to start by doing an overview, if you will, of some of the big things that are going on, because under the current administration, as you know, a lot of immigration changes almost on a daily basis. As I like to tell clients, this information is only as good as the next 3 a.m. tweet by the president, in which case everything I say must be discarded and we start all over again. The pace in the last 3 years has been breakneck in terms of changes and the number of changes. And I know there's many of you who are concerned about what's going on, and there's so much misinformation. So I appreciate the opportunity. Let me start by doing an overview of a few things, and then we'll go into the questions part of this process. So as a general reminder, even before the COVID-19 slowdown and the shutdowns with USCIS and the Department of State, things were still taking a long time to process. I know there were many, many people who kept asking, how do we make it go faster? How can I make this go faster? Unfortunately, if I had that magic pill to make the government of the United States go faster, I wouldn't be working as a lawyer. I'd be on some remote island enjoying a very lovely, lovely drink. So keep in mind that there's only so many things that attorneys can do, people can do. Things are slow right now, and they are notoriously slow by design. But that's true for adjustment of status cases, advanced parole requests, and most concerningly, of course, the employment authorization documents. All of those things are taking way longer. They were taking longer even before we hit this COVID-19 pandemic. Now, the secondary issue that's going on with USCIS right now and with the agency as a whole is that transparency is at an all-time low. It used to be that people would come in and say, hey, I need this information from USCIS, can you help us get it? And attorneys in particular had back channels that we used to go into that would allow us to inquire on your case or get some other information. All of those channels have been shut down. There are very limited avenues right now that are still available. The number one thing, if you're experiencing a delay, is to reach out to a congressperson. Again, their back channel. If it's a Republican congressperson, you're going to get even more traction than if it's a Democratic one. There are back channels that exist within the agency that allow you to, or allow them to get information that even an attorney is not going to be able to get. But even still, we do, even as lawyers, have a few, very few, but few back channels still available to us to try and get some more information. But those back channels are for information. There's really not any way for me to make them go any faster than they want to. One other thing that we were seeing even before the COVID-19 issue is that there was an increase in requests for evidence. There was increases in denial rates. There were increases in people being placed in deportation proceedings, which I will discuss in a little bit. So we were already starting to see this. What we know from the last 3 years is that this administration is incredibly harsh on immigration. We don't think that's going to get any better. And I will tell you, unfortunately, if in fact he is reelected, it is going to get worse. It is going to get harder. It is going to get more restrictive. So, you know, we'll see what November brings. But right now, some of those things that were happening before are going, what we anticipate is going to happen is it's going to get even worse, especially as the states and the nation as a whole starts to come off of this lockdown. There are a few things that have become quite problematic, and I'm going to start with the public charge. So, and this is just in order of how, in terms of the least recent. So this was back in February 24th of 2020. USCIS implemented the inadmissibility on the public charge. Now, I have noticed there's lots and lots and lots of bad information out there on the public charge. So what is this public charge and how does it impact you? Public charge does not apply to all immigrants. This law mainly impacts those seeking permanent resident status or a green card through family member petitions. That's it. So in immigration law, public charge is a ground of inadmissibility. This law says that those who are viewed as more likely to become dependent on the government in the future as a public charge are inadmissible. And grounds of inadmissibility only apply to those who are seeking entry at the border or they're seeking an adjustment of status in the United States. So if you have your green card, this isn't going to apply to you. Many immigrant categories are exempt from the public charge of ground of inadmissibility, even if they are applying for a status as a green card. So for example, if you are looking for, or you are going to get your green card through a U visa or a T visa or as an asylee, then the public charge laws do not, or well, the public charge ground of inadmissibility no longer applies to you. And again, as I said, it doesn't apply to someone who is already a lawful permanent resident. So if you're applying for citizenship, this is not going to bar you from getting citizenship. You'd be surprised how many people think it will. It does not. Now, until now, most public benefits or using public benefits was not a barrier to legal status in the United States, which was basically the policy of the United States for the last 2 decades. The new rules under public charge will be where they will punish a recipient of vital health, housing, and nutrition programs, including federally funded Medicaid and SNAP benefits, or food stamps, and Section 8 housing. So, you know, if you have a situation where you've had Medicaid in the past, and now you have your green card, it doesn't apply to you. Even within the Medicaid requirements, there are some exceptions for like emergency services, pregnant women. I think there's a couple of exceptions there as well. So there are exceptions, but overarchingly, it is going to have very large impact on people who are immigrating through a family-based petition. So what does the agency look at? They look at factors such as your economic situation, so the person coming in, their economic situation, education and health. Now, why is that important? So if you are applying for mom and dad are 80 years old, they aren't going to necessarily have employability. You're not going to be able to put mom and dad to work at the age of 80. That is going to now be an issue that they're going to look at. And they're going to say, well, because they're 80, we need to now see if they have particular insurance. Are they going to have travel insurance while they're in the United States? If they're waiting on a green card, are they going to have insurance to cover any medical issues? So that, those kinds of issues are going to come up. And so when you are looking at that, whether in the United States or outside of the United States, those issues need to be addressed. If you're coming in, I want my family to come in on a visitor visa. Even that is now having issues with regards to the embassy saying, well, we want to make sure you're not going to go to the United States and then need medical assistance, or you're not going to need food stamps, or you're going to have a place to stay. So some of that requirement, some of those, that scrutinization is going to get more and more. Now, for those who are interested in the technical piece of this, the public charge form at the consulates that's going to become necessary is called the form DS-5540. And for adjustment of status here in the United States, it's going to be the form I-944. So if you start to listen to lawyers ask you about that, that's what they're talking about. They're talking about the public charge issue. The next big issue I want to talk about is all of the changes that have been going on with the COVID-19 situation. Now, USCIS has had its doors closed and will have them closed until June 4th. The service centers are open, which means they are accepting filings. So people say, well, can I file for citizenship? Yes. Can I file for my spouse? Yes. Can I file for, a change of status? Yes, you can do all of those things because the service centers remain open. What has been suspended predominantly is the biometrics appointments are all suspended. So if you have a fingerprint notice, you can't go until they open up the biometrics. Even if it's expired. So if your fingerprint appointment was on, April 30th, doesn't matter. When USCIS reopens, they will honor those fingerprint appointments and you'll be able to go in and get those done. The other thing that is suspended is any interview. All interviews have been suspended at least until June 4th. So if you are waiting on a citizenship interview, going to get delayed. Waiting on a green card interview, going to get delayed. Waiting on a 751 interview, it's all going to get delayed. There's nothing I can do, nothing any lawyer can do, there's nothing anyone can do to make that go faster. Now, historically, in an election year, they tend to do citizenship applications first. Now, it is my belief, and this is purely belief, that once they reopen the government, that they will rush to get the citizenship applications done ahead of an adjustment application. So part of the reason for that, of course, is because there's delays in there's deadlines for when you can register to vote, and they're going to try and get that done before the deadline closes on voter registration. So if you're waiting on, your spouse or a parent or a brother or whatever, if you file an application for them, it's going to be a while before you get to an interview. The other issue that is coming up right now is that there have been deadlines, right? So let's say you file for something, there is or you are waiting on, let's say your visa expires. You were here on an I-94, your parents were here on a B1, B2, and they can't leave. Well, because India's on lockdown, or they can't leave for other reasons. File the extension. Okay, and you're going to want to apply for that extension before the expiration of the I-94. You're not going to want to wait for it to lapse and then file. That said, USCIS has said that even in a situation where someone's I-94 has expired and they have not yet filed for extension, they should document what caused the delay. And they are going to consider the COVID-19 issue as an extraordinary circumstance. So if there's for some reason you couldn't get it done on time, get it done, but document it to show why it is that it was delayed. RFE deadline. So let's say you have an application pending, but you have a request for evidence, you have a notice of intent to terminate, you have a notice of intent to revoke, all of those things going on. Those are a little bit tricky in the sense that an RFE request that was issued between March 1st and May 1st, there is an automatic 60-day extension. So what that does is if you had an RFE that was issued on March 1st and you were supposed to have your information to immigration in 30 days, there's an automatic extension of 60 days from the end of the date, from the deadline from the due date originally. So for example, if it was March 1st and you had 30 days, so when the 30 days come and go, now you have an additional 60 days at the end of it. So it really actually converts it into 90 days. The issue that people are going to have is let's say that your RFE was not dated on March 1st, it was dated on February 28th. In that situation, there is no automatic extension. There is a lawsuit that has been filed. It is pending. There has not been much movement on it. But there was a pending lawsuit that the American Immigration Lawyers Association filed to say, look, this is pretty arbitrary in your application, and therefore you should let all and suspend all deadlines. At this point, that has not occurred. So if you have a deadline that is prior to March 1, that notice of intent to deny, notice of intent to revoke, notice of intent to terminate, or a request for evidence, if any of those things were due, then you need to make sure that you're careful on that deadline. If you are taking an appeal on an I-290B, so you applied for a benefit, that benefit was denied, you must now file an I-290B. Again, same rules apply. If it is within March 1st to May 1st, that extra 60 days comes into play. Otherwise, you've got to file on time. That is incredibly important. And I know for a fact that there's misinformation about that one out there. So if you know of anybody who's got that kind of a situation, make sure that they go talk to an attorney right away. The final thing I want to talk about, and then I'm going to open it up to some questions, is this. The April 22nd, 2020 proclamation on the restrictions imposed for immigrants that went into effect on Thursday, April 23rd at 11:59 p.m. It suspends the entry of any individual seeking to enter the United States and does not have a valid immigrant visa on the effective date or a valid travel document, a transportation letter, an advance parole document. If you don't have any of those documents, then you are not. Then those are the issues. The proclamation is focused on those individuals. It does not include non-immigrant visas at this time, although I think that ultimately it may. So the immigration courts right now are not having any detained hearings. So that means if you are, they're having all detained hearings. All non-detained hearings are suspended through May 15th. All right, so with regards to the immigration courts, like I say, the detained hearings are all suspended until May 15th, but this is a daily changing kind of a scenario, and we do anticipate that there will be some aggressive enforcement once the lockdown is over. So with that, I am going to try and address some of the questions. I do ask that everyone be respectful of one another, but let me see if I can see. It says, what is the impact on an F1 visa? Okay, let me answer some of those as well. All right, let me go through some of the questions that came in. I think we'll address some of the questions that are already here. I promise this will answer your question as well. So it says, one of the questions that came in is I am a student preparing for the US MLE on an F1 visa. My I-20 expired on May 1st and my grace period ends on July 1st. I intend to go back to India before my grace period ended. so that I wouldn't fall out of status, but looking at, all right. So for example, with this question, let's go back to talking about this gentleman who is on an F1, but is preparing for the US MLE. First off, let me start by saying, you know, the answers to these questions are not legal advice. And the number one issue we always run into as lawyers is that people will ask questions in a vacuum. And part of the problem is that we can't always answer the question in a vacuum. There's a lot of information that becomes necessary and required. So for example, in this instance, there's really not enough information that's been provided and not enough background information that's been provided. But what I can tell you is based on the current administration, it is unlikely that a B2 change in status is going to be granted, and that if you try and file for a B2 at this point, you're likely to fall out of status and incur what's called unlawful presence. So in this instance, if the grace period ends in July, and I think there are some issues in this with this gentleman trying to change his status to a F1 from an F1, especially during the grace period. I think for him, the best result may be simply to leave the country and then return at a later time. The second question that I received says myself and my spouse are permanent residents since July of 2010. Our green cards are about to expire on July 14th of 2020. We both applied for citizenship in March and applied for a green card extension along with an I-90. And we've got the receipt notices. What would be our legal status once our green cards have expired? You're still a green card holder. So you are still a lawful permanent resident based on what's in the government's computer, not necessarily what's on your card. What will be our employment status? Same thing. You would still be a lawful permanent resident, and so it doesn't change your ability to work or travel or do anything else that a lawful permanent resident does. However, if the card itself has expired, you are going to need to have some way or some process by which to show that status. And the way you do that is generally you go to USCIS and you ask them to stamp your passport. Unfortunately, USCIS is not open at this time, so I would tell you to restrict your travel until that occurs. Next question says, my parents have a green card. They were scheduled to come back to the United States last week. They have been out of the U.S. since November of 2019 and are unable to return to the United States because of the lockdown. Will this be considered abandonment of the green card if they are unable to come back within 6 months from departure? No, abandonment doesn't work like that. So generally when you're talking about abandoning your green card, what you're talking about is that you packed up all your stuff. You don't have the intent to return, you don't have any connections left with the United States, and you simply leave the country and you don't come back. And there is a presumption of abandonment when you are out of the country for at least a year or more. So technically, up to 364 days out of the country, if your parents came back to the country, they would still, under the law, not be deemed to have abandoned their green card. However, what's likely to happen is that when they show up at the Border Patrol is going to say, you've been gone a long time, and we don't know if you are really living in the United States or if you are actually just using your green card as a visitor visa. As a note of caution, I will tell you that individuals, especially elderly parents, things like that, who use their green cards as a visitor visa and show up for every 2 months out of the year or something like that, they are at risk of having their green cards revoked because they aren't, Customs and Border Patrol is going to reach the conclusion that you're using it as a visitor visa and it's not the same thing. So that isn't, but for purposes of this question, that is not an abandonment. All right, next question. It says, how does this temporary suspension, how would it affect those individuals who have completed their interview process at the embassy already, but waiting for stamping in their passports? If it is an immigrant visa, now this question doesn't tell me if it's for immigrant or non-immigrant visa, but if it is for an immigrant visa, yes, it will be a case that is impacted at the embassy at least for the next 60 days. If it is a non-immigrant visa, then no, then it should not be subject to the ban that was announced or the proclamation. Due to the coronavirus, do you think embassies could ask to redo the medical once they're open again and before they stamp the individual's passport? Yes. If by the time the visa comes, so let's say at the end of 50 days, there's a recommendation to extend the ban, and that keeps going on, it is possible, and we can talk about that. It is possible. But if that occurs, then can the embassy ask for a new medical? Yes, they can. If it has been over a year or more has gone by since the submission of the medical. So that is possible to have happen. How likely will the embassy process those cases faster after the suspension period over the embassy? So I think what the question is they're asking is will they prioritize these cases that are being put on hold as opposed to other cases? Honestly, I get these kinds of questions all the time, and I always tell people I don't work for the government. I don't know how they think. I don't know how they prioritize. I have no idea what they're going to do in terms of how they prioritize their casework. So unfortunately, there's really no way to answer that question. Finally, it says, I've heard from a grapevine that the family preference 4th category immigrant visas will be discontinued sometime in the near future. How likely is the president to sign this bill? Okay, well, this question brings out a very interesting thing, and that is that whenever you hear the president tweet about all of these things, you have to take it with a grain of salt. And that is partly because the laws cannot be changed by him. So all of these bans and all of these restrictions that you're seeing, this is just a very distilled way of applying the laws as they exist today. These are not new laws. These are just the application and the interpretation of the laws as they exist. So in this instance, if they were going to fundamentally take away the family-based 4th preference category, then yes, that's going to take an act of Congress. That is not going to take an act of the president. And currently, the makeup of Congress is such that will never pass the House of Representatives because the Democrats continue to hold the majority. And this is so far outside the Democratic platform that it just will never pass that House. And so if it doesn't pass the House, it doesn't, you can't, and a bill doesn't become a law like that. So I don't think any of that is going to happen. Are you going to see these increased restrictions? Yes. Why are you seeing these restrictions? Because these are the efforts that the administration can use effectively with the laws that currently exist. All right. Next question. My parents, who are visitors to the U.S., are originally planned to go back to India in March. Because of the coronavirus, because of COVID, the plans did not happen and their I-94 dates have lapsed. I applied for an extension 10 days before and got a response from USCIS. The biometrics appointment came and went. What can I do? As I said, filing the extension was the right thing to do. And that is the exact same thing to do. You can't do anything about the biometrics. Once the government reopens, you can have them go take their biometrics at that time. All right, let me see. It says, I'm a student on an F1 and currently in my grace period. I'm unable to go back to India. Yes, what would you suggest me do if I'm unable to leave at the end of the grace period? Well, I mean, the students right now don't have an automatic extension. You are still in a duration of status state. So there are lawsuits that are in place right now. There's a nationwide injunction with regards to that. that keeps you from accruing unlawful presence. And what unlawful presence is it is the time that you are present in the United States without authority. And because student visas don't usually have an expiration date, they usually have what is called a duration of status, which means as long as you are complying with your student requirements, then you remain in status. Now, if you've graduated, or you haven't graduated and you're just kind of waiting, you haven't accrued unlawful presence at this time because there's not been a formal finding that you are out of status. And for students, it's this weird thing in the law that says that either USCIS or an immigration official or somebody has to make a determination to say you are now out of status. And only then can you accrue unlawful presence. And I know I'm getting in the weeds a little bit, but for purposes of your question, if you cannot leave by the grace period, understand that you probably are not accruing unlawful status. Unlawful presence, but technically you are out of status at this point. All right. So now there were also a number of other questions that had come in. Let me look at this one. It says, now this one I couldn't really answer because there's certainly not enough information. And it says, is it safe to switch jobs in the current situation? I don't know what that means. I'm sorry, I just don't know what that means. But I will answer the rest of these questions. It says, if there was an amendment in the current job due to significant decrease in salary, is it wise to apply for another job and visa through new employer? I'm assuming what you're talking about there is an H-1B, but again, I don't, that question does not give me enough information. But assuming you're talking about the H-1B there, is it wise to apply for another job and a visa through a new employer? That's kind of up to you whether you want to do that. What would happen if either the amendment or visa application from the new employer gets rejected? You could fall out of status. You could have some severe consequences if both of them get rejected. Part of the thing about that is that when they reject or deny these applications, what they do is they backdate it to the date of the filing. And so now it can cause some issues for you. Can an H-1B employee be furloughed? Yes, as long as you are being paid. If you are discharged, the employer is, so if you are fired and not just laid off, if you are completely discharged from employment, then at that point, the employer is required to pay a reasonable amount towards your transportation home. And if not, if you're just furloughed, then yes, as long as you're being paid. So it's kind of odd as well. USCIS doesn't care if you're actually working. They care if you're being carried on the payroll. So as long as you're getting paid, that's fine. And how long can that go on? There's no time limit. As long as the employer wants to continue to pay you, then that's certainly up to the employer. In the unfortunate situation when an H-1B employee is laid off, how long can you stay legally here? You do have a 60-day grace period for that. If you find another job sometime after losing the job and the new employer files for the visa, can we start working immediately? No. And the reason for that is because you need to have a petition and an LCA filed. Does the portability law apply even where there is a small gap in employment status? It does, as long as the petition and the LCA has been filed within the gap. All right. And the last question this person asks is, when will premium processing start? Again, I don't have a crystal ball. No way for me to know when that will happen. At this point, premium processing has been suspended indefinitely. All right. Next question. There are rumors that there's an automatic extension of I-94s for 1 year, irrespective of status. For example, H-1s or F-1s. Is it all rumors? Yeah, it's all made up. That's just not true. It's not. There's nothing in the law. There's nothing in policy. There's nothing anywhere that specifically asks or authorizes something like that. So it's not true. All right. So it says, there was news today that USCIS has allowed an additional 60 days to respond to RFEs. What does it cover? I think I've already answered that question in the beginning with regards to how the RFEs work and what is encompassed in there. But if someone has a follow-up question to that, you're more than welcome to put it in the chat box. Let's see. I'm just going to finish these questions before I do the chat questions real fast. I'm working at home these days. Does my H-1B need an amendment if the city state is different from the place of work? No. As long as it's within the same area of employment, generally the normal commuting distance is what they look at, and all the terms and conditions of employment remain the same. There are some notice requirements for the employer, and they should probably make sure that they address those notice requirements. So you may want to make sure with the employer that they have complied with those notice requirements. Premium processing for all categories, is it still available? No, still, again, suspended until all further notice at this time. All right, in case of furloughs, what happens to my H-1B? Do we need to get paid irrespective of being furloughed? Similarly, if I'm forced to take my vacation days with no pay, is that allowed? So I've already discussed the furloughs issue. With regards to if you're forced to take your vacation days with no pay, that is impermissible. So if the employer says, look, you must first take your vacation days, your paid vacation days, that's permissible. Unless, so there is a new law that was passed to protect people who were taking days off for family care of individuals who were diagnosed with the coronavirus. Now, under those situations, the employer cannot force you to take your paid leave first. It's a separate protection for employers that has its own set of guidelines. But in this, with regards to this question, it's talking in terms of an H-1B. No, you cannot be forced without pay. In fact, it's a violation, and it'll throw you out of status. So that is a problem. Temporary wage reductions. Do we need to file an amendment to the H-1B? Yes. Any material change in the terms and conditions of employment or training would require a new LCA from the Department of Labor and to file an amended H-1B petition with the new hours and the new wages. So yes, you would have to have that done. All right, it says, I am on a student visa. Can we stay away, meaning in a different state, from the area where the school is due to COVID-19? Yes. Students who are now remotely working from, a different state or a different place, you're still in status, you're still maintaining the conditions of your visa, so long as you are maintaining your class requirements and your enrollment requirements. If you fall out of status, it's because you're doing something you're not supposed to be doing. Now, does that mean you can sit at the computer, take your classes, and then get done and then go work at the gas station down the streets under the table? No, that's still a violation of the conditions of your visa. It will come back and haunt you. That's information that's out there incorrectly in the community, and one that causes a lot of stress and heartache to a lot of people down the road, because it is a violation. Most common question I get asked about that is, well, yeah, but how will they know? The way they will know is on almost every single form that you file with immigration, they ask you biographic information. And so if they're asking you biographic information, you've got to put that down honestly, because if they figure it out, then you have not only lied to an immigration officer and committed a misrep, but you've committed perjury, both of which is a crime. So not recommended under any circumstance. All right, I'm almost done with these questions, I think. The next one is, what happens when one gets laid off? When CPT, OPT is under extension, what happens if we don't find a job in 60 days? Am I still in status? You are still in status, but only for 90 days. Thereafter, you're going to fall out of status, and there is no grace period. All right. New H-1B filings that started April 1st. Any news or insight on that? So the proclamation, remember, says so far does not apply to non-immigrant visa holders. However, they will go back and they will review that and see whether or not there is a need to extend the program. There's also, within the proclamation itself, there's a requirement that says within 90 days of the effective date, the Secretary of Labor and the Department of Homeland Security, in consultation with the Department of State, shall review, so that's mandatory, non-immigrant programs, H-1B would be one of those programs, and recommend to the President other appropriate measures to stimulate the U.S. economy and ensure, quote, the prioritization, hiring, and employment of U.S. workers. So how are they going to implement that? Again, don't have a crystal ball, don't know. Is it something that's going to potentially be a problem? Yes, it is potentially going to be a problem, something to kind of keep an eye on and watch for. Next, it says, I heard that F1 students, though they filed their taxes during the previous year, are not eligible for stimulus checks. What if I got one? Do I cash it? Yes, go cash it. The issue is not whether they, so the problem is that I don't think Congress originally intended for students who were working and filed their taxes to get the stimulus checks. I don't think there was an intent to do that. However, the law is just not written that way. So it's an example of a poorly written law where the intent of Congress is not really, it doesn't come through in the words that are written. And so there's nothing illegal about cashing that check. There's no criminal liability, civil liability, no penalty. Yeah, you can cash it. Now, there are some mutterings about what are they going to do with the checks that are cashed. Now that remains to be seen. Well, in honesty, I don't think that there is really anything. It's just a poorly written law, and that's just kind of how it happened. There are some provisions. I think there are some issues right now that are with regards to the stimulus checks and things like that. The other issue that's come up is that you have mixed families. So let's say you have one person in the family who is undocumented and someone else who is a U.S. citizen. Under those situations, they are not giving stimulus checks to those families. And there are lawsuits that are, again, pending. How is that going to play out? Don't know, but that is one of those things that we'll have to wait and see on. All right, it says an H-4 EAD holder, can an H-4 EAD holder apply for unemployment benefits? Yes, you can. Unemployment benefits is not public charge. It is not considered as one of the things that they look at for purposes of a public charge. Does it come under the new public charge? No. And does the stimulus check come under the public charge? No, it does not either. So none of those things are going to be considered part of the public charge. All right, it says, if I am graduating now and don't find a job within 90 days, does my F1 turn into unlawful presence, even though the current COVID-19 situation makes it difficult for finding a job? Yes, it does. You are out of status for purposes of employment, but not necessarily accruing unlawful presence because of the nationwide injunction against USCIS. It is a tricky situation, and it is a difficult situation. Once we come out of this pandemic, is there going to be additional lawsuits? I probably think there will. However, what is the outcome of that? What's going to happen? Again, those are things that we don't know. What I can tell you is it probably makes sense to take a conservative approach rather than a broader approach. If you go, should I leave or should I stay? If you're still within the grace period, you may want to leave, because then you can honestly say, look, I didn't violate any of the terms and conditions. It makes it easier to come back. All right. It says visiting parents here on a B1, B2 need to travel back soon. Do we need to file for extension even if it is due to India having closed down incoming flights? Yes, I would tell you definitely file for the extension. If it's already expired, apply anyways. And again, just document to show why the extension should be filed. All right. What if H1 extension gets denied during this time? What are my options? Is COVID-19 a compelling circumstance to file for an I-140 EADS? We don't have enough information in this question, so I can't really properly answer that one. But I will tell you that COVID-19 is not going to be declared to be a compelling circumstance for an EAD. And the reason is because I think you're going to run straight into this proclamation that says we're going to prioritize U.S. workers. So I think there is going to be some concerns with that. I think, again, I don't have enough information in that question, but in my opinion, I think it's unlikely to be a compelling circumstances. So those are all the written questions. And I know there's only about 7 minutes left, and I'm going to try and get through the rest of these. If you are, and before I start trying to answer some of these, and it's up to IAKC, I can certainly stay on to answer these if you like a few extra minutes.
Yes, please.
Okay. So let me see if I can get through these real fast. One other thing that I am going to, before I start answering these questions, I am going to kind of put out there is look, it is an ever-changing scenario. And like I said, I cannot stress that enough. There is so many things that change overnight. You can get off the phone with your lawyer and the next day they're going to call you back and say, well, it changed. That's just the nature of what is going on. That doesn't mean your lawyer's stupid. It doesn't mean they didn't pay attention. It just means that's how fast things are moving. So keep in mind that it's always necessary to stay vigilant in what's going on. For those of you who want, you can get on our Facebook page. It's Sharma-Crawford Attorneys at Law. We update. I mean, it's pretty regularly updated. So we will do that. If you message me on Facebook and ask me a question, 9 out of 10 times, unless it is a general question, you will get the answer that says, I'm not going to answer case-specific questions on Facebook for a variety of reasons. For privacy reasons, security reasons, as you just saw earlier in this session, incorrect people get on, and you just don't want your information shared. It's not a wise idea. Don't ask those questions on a public forum like that. And secondly, it's kind of like when you never go to the doctor. I guess this is the easiest way to explain it. You never go to the doctor and say, hey, my friend has a stomachache. Can you give me some medicine for my friend? People think it's slightly different for lawyers because, well, I'm just giving you my information, all these facts. Until somebody has a proper understanding of the facts of your specific case, the rest of it is just general information. So take it for what you will. All right. So that's my plug out there for the caveat on that. All right. It says I am a student on F1 and currently in my grace period. I'm unable to go back. I think I answered that one already. Can I change status from an F1 to B1 during my grace period as I'm unable to? I just think you're going to have a hard time. Okay. So the issue is that, an F1 to a B1, B2, you have to be able to show the reason for the change. I just think you're going to have a hard time. Can you do it? You can. You can file the change of status, and arguably, they will take it. But the problem becomes is, again, remember, if they deny it and they backdate it to the date that you fell out of status. And at that point, they're going to say you're out of status. And remember, for an F1, you need somebody to say you are out of status in order to start accruing unlawful presence. And there you go. That denial is going to now say you are out of status. So now you will start to accrue unlawful presence. All right. I am currently on an L1. I am in the middle of relocation to Asia and have started remotely handling an operational team. I am just waiting on the COVID situation to resume international travel, should I change my current status? Again, I don't think that that's going to be successful. You know, it's good. L1, same kind of thing, is you have to be able to show that you are still continuing to comply with your visa requirements. If you are, it doesn't matter if you're doing it at home or someplace else and handling it remotely. You just have to be able to show you are complying with the requirements. H-4 EAT's going away? Yeah, probably. Unfortunately, this is one of those things that the administration has made it their effort to do away with. It makes no sense. I think that they are going to use the current economy and the employment scenario and the rate of unemployment as a justification. I believe that it is going to go away. I think every indication that we have says that it will. All right. Whether using Obamacare benefits would disqualify someone from keeping green card or getting citizenship. No. Obamacare, again, remember, I think what you're asking there, and I'm not sure exactly, but I think what you're asking is that going to be any kind of a public charge or anything like that? It's not. You know, if you're getting Obamacare benefits, that isn't going to apply for you. Again, remember, those public charge issues only apply to someone who is applying for their green card or for status in the United States. It doesn't have anything to do with citizenship, so no. Okay, and I think the last question, I may actually have gotten this through in time. How can a student on F1 in grace period go back to India if there are no international flights? Well, again, remember, India is saying that they are going to be reopening on May 18th, I think is the latest reopening. And so if May 18th is the reopening, then you leave as quickly past that as you can. Keep your documentation. So what I mean by that is this, is again, remember, on an F1, you are not accruing unlawful presence. So if you have to go back, you go back to India, you visit family, you say, okay, I'm going back on my F1, but, or I was in my grace period, I couldn't leave, here's what's happened, and I left as soon as I could. Now, one of the things that USCIS has said, and as well as the Department of State has said, is that, look, when we come out from this lockdown, we're going to have some flexibility. And USCIS officers and the Department of State officers are going to exercise some level of flexibility as it comes to making these discretionary decisions. And what I mean by that is if there's nothing in the law that prevents you from getting the visa, but there is a technical issue in play. I didn't leave until the lockdown was lifted in India. I got on a plane and I left, but as a result, I am now 5 days outside my grace period. That right there is going to be an issue that USCIS officers or Department of State officers are going to look at in order to consider what happens on your ability to come back or your ability to change into a different visa. And they are saying that they will use increased flexibility with regards to those types of issues. So I wouldn't sweat it, but I would probably not push it off so far, it's too far in order to do that. All right, with that, I'm going to give you a couple of closing things. I think those are all of the questions. I would ask that, again, if there are any other questions, there's a couple places you can get those questions answered. Number one, you can continue to email IAKC and they will forward me your emails if they come in. Number two, you can always follow our Facebook page. If you have a question, you can always also on the Together SATSAT page, if you want, you can also drop me an email. I get emails from that all the time, or even messages on that page all the time. Again, just for general information, if you have a case-specific situation, the best thing you can do is go and talk to an attorney one-on-one and take all of your documents with you, okay? I think that's it. I don't have any other questions, so unless anybody else have any other questions, everybody stay safe. Be careful, and thank you for the opportunity.
Thank you very much for your time. I appreciate it. And hope to have more sessions like this. Stay safe. Thank you.
All right. Thank you. Namaste, everyone. Have a good evening. Bye-bye.
Thank you, everyone. Thank you, Rekha ji.